Welcome back to The Legal Brief, the show where we crush the various legal myths and misinformation surrounding various areas of the gun world. I'm your host, Adam Kraut, and today we're going to talk about the lawsuit the National Shooting Sports Foundation, or NSSF, has filed against the Attorney General of Massachusetts.
Have you ever wondered how many things you can attach to your gun with the KDG Connect and side lock mounts? It's a lot. But just because you can, doesn't mean you should. Kinetic Development Group. Keep it simple, stupid. To get 10% off your entire order, use the code TGC10 at kineticdg.com.
As many of you know, on July 19th, the Attorney General of Massachusetts shocked gun owners by sending out a guidance which reinterpreted the state's assault weapons ban to include pretty much everything under the sun. Overnight, without input from the public, any hearings, or litigation, the state's Attorney General single-handedly changed what was commonly understood to be banned to include far more than the legislature ever intended. As a result, the NSSF and 4 gun shops have filed an action seeking declaratory and injunctive relief from this nonsense. For those of you that don't know, declaratory relief is when a party asks a court to determine what their rights are under either a contract or a statute. So this is when a person is trying to have a court determine what they can or cannot do. Injunctive relief is when a court orders a party to refrain from engaging in certain conduct. This is when a court orders a party to knock it off. While we're at it, we'll knock out one other term here. Unconstitutionally vague is when a statute is found to violate the due process clause of the 5th and 14th Amendments because a person cannot reasonably understand what conduct is prohibited under the law. This is when a court says that no one can understand what you mean, so we can't punish people for you being unclear. The NSSF alleges that the Attorney General's enforcement notice is unconstitutionally vague, violating both the 5th and 14th Amendments, and exceeds her lawful authority.
You're out of order! You're out of order!
The complaint recounts the passing of the federal assault weapons ban, which expired in 2004, some of the legislative history behind that one, and Massachusetts' adoption of its own assault weapons ban in 1998. Of specific interest is the information that's in paragraphs 32 through 38, which explains what the Massachusetts legislator understood the term copy to actually mean. That being the same thing the federal legislature understood it to mean, which was that a copy did not refer to the firearms operating system, but rather it prohibited those specifically named manufacturers from simply renaming the firearm to avoid the legislative ban. To further the point, everyone's favorite Senator Uncle Two Blast Joe Biden, during the debate on the federal assault weapons ban, stated that to avoid the so-called copycat problem where manufacturers simply rename a gun to avoid a state assault weapon ban, the amendment makes clear that replicas and duplicates of the listed firearms are covered as well. Additionally, he stated, to make clear that this ban applies only to military-style assault weapons, this ban would apply only to semi-automatic rifles and pistols that can either accept a detachable magazine and have at least 2 of the following characteristics: a grenade launcher, a flash suppressor, a bayonet mount, a folding stock, or a pistol grip. More succinctly put, everything that's fun. The Attorney General made a bigger mess of an already messy situation when she released her follow-up notice, Guns That Are Not Assault Weapons. This had several iterations, which began with any .22 caliber rifle was not an assault rifle or a copy of one, then that only any semi-automatic .22 caliber rimfire rifle was not an assault rifle or a copy, and oddly enough, she also included in that one that M1As or any copies thereof were not assault rifles, and then again modified to include 17 caliber rimfire rifles as not being included. In other words, now retailers and gun owners have no idea what is acceptable or not, and the only advice the Attorney General's office would provide to retailers who were parties to this complaint was, quote, use your best judgment. See why this is vague? The complaint alleges that the language appearing in the enforcement notice is too vague for retailers, distributors, and manufacturers to understand because it does not adequately define what it means by the phrase contained in the new regulation, quote, operating system and firing mechanism of the weapon are based on or otherwise substantially similar to one of the enumerated weapons, end quote. This creates 2 categories of firearms. The first being that those are substantially similar because they operate via gas blowback, direct impingement, or with a piston, essentially encompassing all semi-automatic firearms. The second being those that are able to share parts, which creates a smaller category of firearms, but either way the result being individuals cannot reasonably comply with the law because it is so vague as to what is legal and what is not. The complaint goes on to give comparisons between different firearms sold by the retailers and why this creates confusion as to what is legal. The NSSF requests that a court declare the enforcement notice is unconstitutionally vague, that the Attorney General has exceeded her authority, and that the Massachusetts statute specifically incorporates the definitions which appeared in the federal assault weapons ban, which does not ban firearms based on their internal operating system or interchangeable receiver parts. It goes on to ask the court to issue an injunction preventing the Attorney General from enforcing the enforcement notice or her diluted definition of a copy or duplication of an enumerated firearm. So essentially, the NSSF is seeking to have a court declare the Attorney General's interpretation is wrong, and to order that she can enforce her diluted interpretation of the statute, thus allowing retailers to conduct business in a manner where they know what is legal. Hopefully that gives you guys a brief overview of the litigation that's about to ensue. We're going to try and keep you updated as it goes through the process up there. If you guys like this episode, you know what to do. Hit that big old like button, share it around social media with your friends to help spread the knowledge. Have a question that you want answered on the show? Head on over to theguncollective.com and click on the legal brief. Don't forget to like The Gun Collective on Facebook, Instagram, YouTube, Full30 Snapchat, and wherever else you can catch us on social media. And as always, thanks for watching.
The shirts worn in today's episode of The Legal Brief have been provided by Patriot Patch. Click the link in the description to learn more.